I am certain that now, as Prime Minister, Datuk Sri Anwar Ibrahim and his government will remain true to those comments by continuing to unreservedly remain committed to upholding the cause of judicial independence. What I am about to share with you next are not my personal views, but actual discussions that took place in the Dewan Rakyat regarding the passing of the Judicial Appointments Commission Act 2009. The need for the Judicial Appointments Commission Act 2009 were grounded on many allegations and attacks against the government. Pertinently, many members of the opposition appeared to express the sentiment that the introduction of the bill to the Judicial Appointments Commission Act 2009 was merely a cover-up for all the past appointments that had been made. I invite each and every one of you to scrutinize the Hansard for 16 December 2008 and 17 December 2008. Most of all, I find relevant the views of the then recently appointed leader of the opposition and current Prime Minister of Malaysia, Datuk Sri Anwar bin Ibrahim, who expressed strong views on the VK Lingam incident. Datuk Sri Anwar Ibrahim concluded then that the Judicial Appointments Commission Act 2009, in his view, was not enough to restore the independence of the judiciary. He went on to observe that there is a perception that persons who had decided in favor of the government were promoted. Datuk Sri Anwar Ibrahim's observation then relates directly to the fundamental aspect of judicial independence, in that perception plays a big part in it. The public cannot be expected to have confidence in the judicial institution, no matter how hard its judges work, if the pervading public perception is that judges are appointed or elevated upon the favor of making decisions that by default support the government of certain business interests. When things like this happen, it is very similar to, if not worse than, the lessons in the children's parable of the boy who cried wolf. Cried wolf wantonly could backfire when no one believes you, when the wolf actually arrives to eat the sheep. Applying it to us, making the irredeemable mistake of rendering one decision colored with bias or appointing one candidate that is only chosen as a favor throws into question the integrity of the entire judiciary, and none of the decisions delivered after that will engender the public confidence and trust, even if that decision is absolutely correct on the facts and the law. It takes decades to instill a steady level of trust and confidence in the judiciary. Judges work hard with considerable commitment towards this end. And since 2016 until now, that goal has largely been realized. Malaysia has improved on all major rule of law and judicial independence indices. In 2023, Malaysia ranked 55th out of 142 countries worldwide in our rule of law ranking, being among the minority of countries whose rankings improved in that year, a significant 23-place improvement from 2016. It is important to acknowledge that these are not merely statistics or empty figures. They denote the reality of how the country is viewed for purposes of investment and are requisites for economic and social progress. The best evidence of this is the research of the 2024 Nobel Prize winners for economics, whose research can briefly be summarized as empirically demonstrating the importance of strong institutions, a key one being the judiciary in fostering long-term and sustainable economic growth. To maintain this reputation, it is imperative that judicial independence, which is central to the rule of law, be upheld and enhanced. From 1988, it is only now that we are on the road to recovery in terms of our perception of independence. Incidentally, 15 years ago, when the Judicial Appointments Commission Act 2009 was enforced, the then leader of the opposition made the comments that he did as reflected in the Hansard on the appointment of judges and judicial independence. I am certain that now, as Prime Minister, Datuk Sri Anwar Ibrahim and his government will remain true to those comments by continuing to unreservedly remain committed to upholding the cause of judicial independence. In spite of the many criticisms leveled against the Judicial Appointments Commission Act 2009 in the debates prior to its passing, the Judicial Appointments Commission Act remains in force. The purpose of the Act, as was clarified by the then government when moving the bill, was not to change the constitutional mechanisms of appointment of judges, but to further streamline and enhance the selection of candidates for judicial appointments. Viewed in this way, the provisions of the Judicial Appointments Commission Act 2009 and the establishment of the JAC is seen as a measure to supplement and complement the constitutional provisions on the appointment of judges of the superior courts. The Judicial Appointments Commission Act 2009 statutorily prescribed selection criteria for potential candidates for judicial appointments. These criteria are evaluated by JAC members who ex officio comprise the Chief Justice, the President of the Court of Appeal, the Chief Judges of the two High Courts, and members appointed by the Prime Minister, namely one Federal Court Judge and 4 eminent persons. Typically, these 4 eminent persons are appointed from among the academia or from the pool of retired judges. These 4 eminent persons cannot be members of the executive or other public service and are appointed by the Prime Minister after consulting the Bar Council of Malaysia, the Sabah Law Society, the Advocates Association of Sarawak, the Attorney General of the Federation, and the Attorney General of a State Legal Service. Aspiring candidates apply to the JAC for appointment as judicial commissioners. The JAC also reviews the performance of sitting Superior Court judges and recommends them for elevation or promotion. These decisions have always been made by a majority vote through a secret ballot if there is no consensus, and in all my time as a member of the JAC, I have not once interfered with the process. The candidate who gets recommended is therefore not the sole choice of the Chief Justice, but either the choice of the majority or the collective decision of the JAC. In my opinion, this is a big improvement from what we did not have before. Any person who interferes with or attempts to interfere with commits an offence and shall on conviction be liable to a fine not exceeding 100,000 ringgit, imprisonment for not more than 2 years, or to both. Candidates that are selected are forwarded to the Prime Minister to appoint in accordance with the provisions of the Constitution. The provisions of the Judicial Appointments Commission Act 2009 do, however, allow the Prime Minister to not accept the candidates recommended by the JAC for appointments. In such cases, the Prime Minister can request for 2 more names of candidates. The mechanism of the Judicial Appointments Commission Act 2009 is far from perfect. As we can see from the parliamentary debates, there are many issues raised against it. Even after its passing, many quarters, including the Bar Council, have recommended changes to strengthen the Act. Foremost concerns the fact that the Prime Minister still has too much power in the appointment of judges. I do not wish to address the recommendations at this point. I am highlighting this to simply bring it back to the attention of the parties present here for possible improvements in the near future. That said, what is clear from the constitutional provisions on the appointment of judges read with the supplementing procedure in the Judicial Appointments Commission Act 2009 is this: no person other than the JAC and the Prime Minister can recommend candidates for appointment to all posts in the superior courts. Any form of circumvention of these provisions could render those appointments either unconstitutional or in breach of written law. For this reason, no person, whether it be the President of the Malaysian Bar, any advocate or solicitor, any political party, the Attorney General, or any other person for that matter, has any business recommending names to the Prime Minister for appointment. For if this is done, not only has the judiciary been trampled upon, its independence has been transgressed and eroded, it is an attempt to interfere with the course of justice by influencing the operations of the judiciary. And any name so considered on such improper advice runs the risk of being challenged via judicial review as being either unconstitutional or in breach of the law. Any person so found to have done this also runs the risk of being charged with an offense. I have been an ardent and firm believer in the independence of the judiciary, including the appointment of its judges. Hence, I have steadfastly observed all the principles espoused in the Constitution and the Judicial Appointments Commission Act 2009. If anyone has any reason to believe that we have not done this, then I would remind you that as the law and procedures stand, the JAC, again, is only but one part of the appointments process, and you should perhaps point the finger elsewhere. As I near the end of my tenure, it is my sincere hope that those responsible for the appointment of judges remember their commitments to their oaths and duties under the Constitution and law and continue to hold true to past comments or commitments that they may have made regarding the fair, independent, and unadulterated appointment of judges. To conclude, I will no longer continue to lead this institution in the coming months. As I leave, I hope that the appointment of the next Chief Justice is fully compliant with all aspects of the law, bearing in mind the need to keep the judiciary independent in view of the unfortunate and blemishing events of history. The law too has developed in a positive manner where fundamental rights and liberties are given their utmost interpretation and enforced to their maximum potential. The role of an independent judiciary has been restored and the public are confident in us. All of us who are serving as judges, practicing at the bar, or even serving in public service will one day slow down to the point where we cannot carry out our current duties either due to law or by age. Let us retire gracefully and happily, knowing full well that we left the institution far better than when we found it. We should gladly sit from afar and beam proudly at its growth rather than viewing it with concern that the judicial institution will turn into nothing but a mere shell of its former glory. To all my colleagues, judicial officers, and support staff of the past and present on the bench, our success as an institution would have only remained as a mere wishful thought without all your dedication and support. For that, I am eternally grateful. I would also like to thank all members of the executive branch of the government, past and present, and Parliament for working with the judiciary to realize all policies, especially so during the most challenging moments of our time during the pandemic. Just a little trivia. My tenure is the first time in the history of this country where a Chief Justice's service has coincided with 4 different prime ministers, all from 4 different political affiliations. In the order of Tun Mahathir Mohamad, Tan Sri Muhyiddin Yassin, Datuk Sri Ismail Sabri Yaakob, and presently, Datuk Sri Anwar Ibrahim. During this time, judicial panels led by me have made what we firmly believe to be correct decisions on the law and facts, regardless of the heated political overtones and undertones that clothe some of those cases. This alone should dispel any baseless notion that I have ever been partial to any political prime minister or any political party. Ultimately, all my thanks and gratitude are owed to Allah subhanahu wa ta'ala, for as I have always said to those close to me, Allah has indeed eased my affairs. We can plan as much as we like to get our way, but in the end, plan as we may, Allah is the ultimate determiner of our fate. I have had the opportunity to work with truly inspirational and brilliant minds, both at the international and local level. All the people that Allah has willed to put in my path have been really kind, helpful, and stellar. I leave you and the judiciary with no regrets. With that, I bid each and every one of you a warm and heartful farewell and a very happy 2025.